Are we ready, Julie?
Yep, we're ready.
Okay. Good morning. My name is Ben Humphries. I'm an attorney in Elizabethtown, Kentucky. I practice law with my law partner and good friend, Lewis Graham. And today we're going to have a workshop for you. This is the 7 threats to your estate plan. And a little bit about us. Lewis and I went to law school together. That's where we met. We practice only estate planning law. That's all the type of cases that we do. We are members of Lawyers with Purpose, which is a nationwide organization focused on estate planning, asset protection, and Medicaid planning. And we have been trained, practice with purpose through Lawyers with Purpose in Syracuse and in Orlando and Atlanta, focusing on trust, irrevocable trust, and asset protection and Medicaid law. And so we have been working very hard to learn about these issues. And today we're going to share with you all some of the information that we've learned to make sure you know the changes in the law that have occurred, the new options that are out there. But also I wanted to tell you that we were called to this really because my own family, when I was a little boy, my grandmother and grandfather, they did not have an estate plan. And my grandfather got sick and my grandmother got dementia. And my father's family ended up having a great struggle over what was best for grandma and grandpa, who should be in control, how things should be handled. And all of them loved each other and they all loved grandma and grandpa, but because grandma and grandpa had failed to do an estate plan, the family ended up not getting along. And so I lost a lot of family reunions. I lost a lot of time with my cousins and my aunts and uncles. And it was really one of the worst things that had happened to me. And so we feel called to help you all, help families avoid what happened to my family. And so that's why we really enjoy this practice of law. We really enjoy this area because it can be so helpful. And so Julia, why don't you go ahead to the next slide for me? All right, go ahead, one more slide for me. All right, so this is our agenda. Normally we would be sending you out a handout, and that would include all the slides of today's workshop. And so you would be able to print those out for yourself or your family. Also, it will include a team information about what we do and who we are. It will also review the 7 threats that we're going to go over today. And then finally, we always like to close with questions and evaluations. All right. And so this is what we're going to cover today. These are the 7 threats to your estate plan: losing control and access to your assets, not knowing the law, not knowing your creditors, your health failing to plan when you can, not working with qualified professionals, and not knowing the real costs. Before we go to that next slide, though, we always tell people we make 3 promises on these workshops, and that you're going to have some fun, that you're going to learn a lot, and that time will fly. And the only thing that we ask of you is that at the end of the workshop that you allow us to reach out to you and just do a little survey about how we did. And it's you just rate us on 1 to 5, and 1 is bad and 5 is great. So I always tell people that if you think we did a job equivalent to a 1 or really bad, it probably means that we need to do some other type of work. We probably don't need to be lawyers, but hopefully you will circle all 5s for us, and hopefully you'll enjoy the workshop. So go ahead, the next slide there, Julia. All right. Threat number 1 is losing control or access to your stuff. And your stuff is your estate. And all of us has stuff. All of us have decisions that must be made. All of us have at least a little bit of property that must be dealt with if we're not able to deal with it or in the event that we die. And so, believe it or not, everybody who's 18 years or older needs an estate plan. Those kids that are in college need medical and business powers of attorney Because guess what? What if they have an accident or illness? They need mom or dad to be able to handle their affairs for them. And so even an 18-year-old person needs powers of attorney, possibly even a will. And even if you have just a small amount of assets, then you need an estate plan. And so everybody's got stuff. And so not having a plan for your stuff is threat number one. Go ahead to the next slide there. So what is estate planning? Estate planning comes down to these three things: who's in control of your stuff, who gets to benefit from your stuff, and when, okay? And so when we're talking about your stuff, remember we're talking about your stocks, your house, your bank accounts, your rental property, your annuities, all the things that you own. That's your stuff. Your cars, your boats, all that stuff. And so who gets to control that stuff and who gets to benefit from that stuff and when, the timing of those things, that is what estate planning is all about, okay? So it comes down to those three things for your stuff, okay? All right, so this slide here talks about losing control or access to your stuff, okay? So the first phase of life there is when you're alive and well. And when we're alive and well, we take that for granted, generally. And also we always believe that we know, or we can plan when we're going to not be alive and well. All of us think that we have this inner voice that'll tell us when we need to get things in order. And so we kind of take it for granted. And that causes some of us to feel like we don't need to go ahead and have an estate plan prepared. And so you never know when you're going to go from alive and well to an accident or illness. And we always tell the people the story of Terry Schiavo. And Terry Schiavo did not plan when she could. Terry was a lady that lived down in Florida. This is a case that I know well because it was going through the appeals courts when I was in law school. And so it's something that we know about because we read about it in law school. And Terry Schiavo was married to Mr. Schiavo. She had two parents. Terry Schiavo had a heart attack. And as a result of the surgeries and medical treatment that she got regarding the heart attack, it caused her to have brain damage. And she went into a coma. And there was a great debate within her family as to what should occur with Terry. Should they pull her off of life support? Should they keep her on life support? Is her coma going to be permanent? Is her coma something she's going to come out of? If she does come out of it, what's her standard of living going to be? All those things. And so, unfortunately, Terry did not have a living will. She did not have powers of attorney. And so when you don't have a plan in place and you have the heart attack, which leads to brain damage, like Terry's case did, your family has to go to court. And so that's what happened with Terry's family. They went to court. They filed lawsuits about the issues of who should get to decide on what type of treatment that Terry should receive, should she be allowed to die naturally? Should she be kept on life support? All those questions. And so the court eventually, down in Florida, this was a very big case in America, the court eventually decided that because Terry did not have a plan, that Terry was going to get the plan that the state provides to those of us who refuse to do estate planning. And that plan down in Florida said that Terry's husband got to decide. And Terry's husband went ahead and pulled Terry off of life support. And so this is, to sum it all up, the Florida court said, if you don't have a plan, you get the state's plan. And the state's plan is not going to be the plan that you have picked out. And it may not be a plan that's good for you or your family. And it also is a reminder that if you don't have a plan, your family's going to end up in court. In Kentucky, if you don't have a power of attorney and you have an accident or illness, then your family has to file for guardianship. They have to essentially file a lawsuit against you, get doctors and psychologists and social workers involved. It's a very costly and process, and it takes quite a bit of time. And uh, and so they've tried to make that process easier. But even with those updates, if there's issues that are unresolved or that are not real clear, you have to have a full-blown trial. And so what we always tell people is that to prepare for having an accident or illness, that you've got to have a medical and a business power of attorney. And we always recommend you have backups on those, and even backups to backups, because just naming one person as your power of attorney, if that person you've named gets sick themselves, then you don't have a power of attorney. So we've had cases where the mom appointed daughter as her power of attorney. Daughter got cancer and could not serve. And so mom, in essence, did not have a power of attorney, and mom had issues and could not sign new powers of attorney. And so not having a backup can be just as bad as not having a power of attorney at all. We do recommend you have a separate medical and a business power of attorney. Those deal with different issues. You may want to appoint different people on there. Also, we don't think that you need to cloud up your business decisions and who's making those and the powers related to those with your medical decisions and end of life decisions, because you may want to keep those private. You may not want everybody to know what you've decided on your end of life decisions, just because you have to show them a power of attorney. So there's a benefit to having both. A lot of people are worried about doing a power of attorney because they're worried about giving a person a blank check. And most powers of attorneys that you see out there that a lot of attorneys do essentially give a blank check to the person you're appointing as your agent, gives them all authority that they could ever want or have. And we do not think that giving a blank check is a good idea. And so our powers of attorney are uniquely tailored to you and your family. And by that, I mean, if you appoint me as your power of attorney, or if you appoint your son as your power of attorney, then I cannot actually act as your power of attorney until I sign a document that's attached to the power of attorney that says I will uphold your estate plan. I will act in a way that's not in conflict with you and your best interest, and I will uphold and act loyally to you. And so your power of attorney is not a blank check. Your power of attorney is something actually that's going to help you. The person you're appointing actually has to do what you want, what's in your best interest. And so it's not a blank check, but you've got to have that extra protection. You've got to have your person you're appointing sign that extra document to make sure that they understand what they're supposed to be doing. If you don't have that on your power of attorney, you've got a potential threat because you're just giving a blank check to your power of attorney that you're appointing. Also, on the medical power of attorney, what you may not understand is if you've gone and you've done a regular medical power of attorney, or you've picked up a living will from the hospital, that living will or medical power of attorney may not be sufficient, and it may not have everything in there that you might want. And we always include in our medical power of attorney the ability for you to say when you should be pulled off life support. So if you pull out your living will or your healthcare power of attorney, I can almost guarantee you that it doesn't say how long you should be on life support. I bet it just says, if I'm on life support, my power of attorney can pull me off, or the person I've nominated can pull me off life support. And so it doesn't say when. And so I always tell about the situation I had with my Aunt Joanne. Aunt Joanne was at an assisted living facility. I was her power of attorney. I had just your generic power of attorney that most of us have had in the past. They just gave me the authority to remove her from life support, but it didn't say when. And so Aunt Joanne went septic. The ambulance was called. They came and picked up Aunt Joanne. Aunt Joanne died on the way to the hospital, and they revived her, which they're required to do. The ambulance drivers have to revive you on your way to the hospital, even if you pass away, even if you've got a living will. That's just what they do, and it's what they're supposed to do. And so they called me from the hospital, and they said, Aunt Joanne is at the hospital. We've revived her. She did pass away on the way here. She's not in good shape. She's on a ventilator, respirator, and all those things. We need you to come down to the hospital and tell us what we should do. I went down there. Aunt Joanne could shake her head up and down or left and right, but she could not verbally make any statements. Okay, and so the doctors were wanting me to say, Ben, what do you want me to do? What do you want to do with Aunt Joanne? Do you want to keep her on life support or not? And it was a terrible situation to be in. It was traumatic. It was emotionally hard for me to be put in that situation. And I read my power of attorney that I had, and it didn't tell me how long is too long for Aunt Joanne to be on life support. How long is too long for Aunt Joanne to be on the respirator or the ventilator? And so, as a result of my experiences with Aunt Joanne, I always recommend to my clients that you put into your medical power of attorney how long is too long, because if you don't, then your loved ones have no guidance, and the doctors have no guidance from you. It just says they can if they deem it to be the right thing to do, and that, unfortunately, that's not really guidance. And so in my medical power of attorney, I've put in there that I want to be taken off life support if I'm on there for 90 days. And you may say, well, that's a long time, Ben. You have to understand, due to COVID-19, where it's possible for me to be on a respirator for a long period of time. But 90 days, if I'm on a respirator and life support and all those things for 90 days and I'm not getting better and I'm not able to communicate, that's what I want to do. That's what I want my family to know that. And so if you don't have that type of language in there, your family is put in a very, very difficult situation. That's something that will really harm them emotionally through the years as they look back upon it, like I did with Aunt Joanne. So the reason we say all that is that we don't recommend using the living wills at the hospital because they just don't have sufficient language in there. We also do not recommend you just use your basic medical power of attorney that was done in the past, because it just doesn't have enough direction in there. Okay, and so you always remember the estate planning documents that you have should be your plan, not just a form that was drafted and used for everybody. It should be tailored to you. Okay, so the only other thing I might add is the power of attorney law changes regularly. It changed back in, I think, 2016, and it's changing again this year, 2020. And it changes dramatically because cases come up where problems have arisen with powers of attorney and the courts change it. And so Kentucky is adopting new laws regarding gifting. And basically, if your power of attorney does not have the proper language in it regarding gifting, then your power of attorney is not going to be able to be used to do estate planning, asset protection, if you should have an accident or illness and have to go into a nursing home. And unfortunately, that's a real problem that happens all the time because people don't pre-plan asset protection enough. They kind of believe things will be okay. And when they're not, they come to us and they say, Ben, we've got this old power of attorney. It just has a basic gifting language in there. Is that going to be enough? And unfortunately, due to the new law changes, that's not going to be enough. Your mom or dad are going to be stuck. They're not going to be able to do asset protection planning if they go into a nursing home or have an accident or illness. And so you got to have those powers of attorney updated. We got to have the new language in there about gifting to make sure that your power of attorney has enough power in there. Okay. And so let's go ahead. Last thing before we go on is powers of attorney end at death. Most people don't know that. So when you're alive and well, you don't need anything, but if you have an accident or illness, obviously you need a medical and a business power of attorney. We even also do a living will. And then those documents actually become void, terminate at your death. And that's when your will or your trust takes over. We've got people come in and say, I'm Dad's power of attorney. He passed away. I'm going to go ahead and keep paying his bills. We tell them we're sorry, but the power of attorney has ended at death. And now the will or the trust takes over. Okay, so a comprehensive plan is not just a power of attorney. It's not just a will. You've got to have wills, living wills, a will or a trust to have a comprehensive plan. Okay, let's go to the next slide. All right, so the next question is, do I need a will or a trust? Okay, and we do estate planning. That's all we do. And so we get this question a lot. We believe that this is the most misunderstood area of estate planning. And the reason we say that is because if you don't understand how a will works, and if you don't understand how owning assets relates to how the will works, then you don't understand how everything works together, okay? And you have to understand the law, You got to understand how assets are owned and how that impacts your estate. And then you have to understand what a will or a trust does in order for you to determine if you need a will or a trust. Some people need a will, some people need a trust. And so really it's more in depth than just the simple question of do I need a will or a trust? All right, let's move on to the next slide, which is our next threat number 2. The threat number 2 to your estate plan is not knowing the law that you think you know. I always tell people that when I finally got out of law school, I got my law degree, and I sat down with my first client. It was in this same office, and she looked at me and she said, "Ben, I think I can still see a little green behind your ears." And I laughed and I said, "Yes, you're right." And so even though I had been through law school, I had gone to undergrad and I'd gone to law school, I'd passed the bar exam, there was still law that I didn't know. I didn't know the law, okay, enough law. And so you all generally have not been to law school, and unfortunately, what you think you know may be wrong. And so that's why we're going to go through this slide. You're not going to get a law degree when you finish this workshop, but hopefully you'll understand more about the law, okay? All right. So here's the law that you need to know that we're going to cover. Types of legal ownership, what a will does, what probate is, what a trust is and how it works, how legal ownership trumps your estate plan, whether you have a will, a trust, both, or neither. Okay? And so let's go to we're going to find out what you all need to know and how these things work together and how understanding these will really help you as you do your estate planning. All right. So types of legal ownership, joint ownership with rights of survivorship, okay? What that means is if you own something jointly with another person, that means that upon your death, it will pass automatically to that other person, okay? And so if you have a car that you own with your spouse, then so I own my Dodge Caravan with my wife jointly and in survivorship. And so what that means is when I die, it automatically goes to my wife. She doesn't have to do anything. She doesn't have to change the title. She doesn't have to get me off of the title. It's hers because I'm no longer there. It was owned jointly and in survivorship. And she doesn't have to go to court about it. And it's hers. Same way with a joint checking account. When I die, it's hers. She doesn't have to go to court about it. She doesn't have to use my will to get it or anything like that. On our house is owned jointly. And so when I die, the house goes to her, and she doesn't have to worry about doing any further work on the estate just to get my half of the asset. So that's joint ownership. When you die, it passes automatically, completely to the person that you own it with. Okay, and so that can be a good thing or a bad thing depending on the asset and how you want it to go. We'll talk about that more. The next thing is a beneficiary designated account. So generally these are IRAs, life insurance, annuities. So these are assets that you own just in your name, but you have designated on the account that they will pass to a beneficiary, such as a spouse, a child, a charitable organization on the account. And so these also do not go through your will. These will pass outside your estate directly to the beneficiary you've designated. And so when you die, the beneficiary just simply submits your death certificate to the company owning the account, and the account will pay out to who they're supposed to pay to. And so this is not going to go through your will or your trust. Now, we always tell people that this is a big issue, that you've got to make sure that you keep a copy of your beneficiary designation pages with your estate planning documents. Because if you don't, and the financial company or the life insurance company loses these documents, loses the beneficiary forms, then you are really in trouble because all this money will have to pass through your estate, which could cause your estate to have to pay much more in taxes than they would have had to pay if they went to the beneficiary you designated, okay? And so we tell people every year, have your financial advisor or life insurance person send you proof of who your beneficiaries are, stick it in your estate planning document file at home and give it to your lawyer, and that will save you a bunch of time and trouble. We actually have a couple of cases right now where the person passed away. The family came in and said, we know that mom or wife had beneficiaries, but they've lost the names. And so there's nothing we could do on that because they didn't save who the beneficiary was. Okay, the family had not taken that extra step. So that's an important point to take care of. Now, payable on death beneficiaries and transfer on death beneficiaries, those are very similar. When you own an account just in your name, similar to a life insurance, and upon your death, it transfers to the person that you've named as the payable on death or transferable on death beneficiary. So this will be like a certificate of deposit that you own at a bank. And so again, this is not going to go through your estate or through your will or through your trust because you've set it up to pay on death to a certain person, somebody else besides your will or trust. Okay. And then finally, an entrust for account. That's generally for a minor. You would hold, like I've got 5 kids. And so I could set up an account in trust for my 5 kids. I'm the owner of the account. When my kids turn 18, they become the owners. The big thing here is make sure you've got beneficiaries on the account if your children should die. Okay. So if your child dies and you die, make sure that you've got contingent beneficiaries on there so that the account doesn't get held up. We actually have an account right now, an estate right now, where they didn't have a contingent beneficiary on there. The child died after turning 18. The account could not be released back to dad because there was no contingent beneficiary. And so we had to open up an estate, close out the account. It's very costly and time consuming to the family. So just go ahead and take that extra step. All right. Last thing on this slide is the assets in your name only. Those are the only assets that are actually going to pass through your will. Okay. Is in your name only. Okay. So that's a big point. Most people don't know. It has to be in your sole name only for it to pass through your will. Okay. Go to the next slide. All right. Next slide on not knowing the law is finding out what a will is. A will names who gets your stuff and who's in charge of your stuff. That's your executor when you die. Remember, a will doesn't take effect until after you die. You can change a will up to the date of your death, provided you're competent to do so. And a will only controls those assets that you own in your name only when you die. It does not control jointly held assets. It does not control payable on death assets. It does not control assets you've got payable on death or transferable on death or in trust for assets. Also, very important to know that a will must go through probate court. So we have a lot of people that we come in and say, you know, my husband died. He's got a will. He leaves everything to me. So we don't have to go to probate court, right? We say, oh, I'm sorry. Unfortunately, he owned assets just in his name. Therefore, we've got to probate that will to use the will to transfer the assets to you. And anytime you're using a will to transfer assets, it's got to go through the probate court process. Okay. So a lot of people don't know that. All right. Let's go to the next slide. Okay. The next slide deals with probate court. A lot of people don't know what probate is. It's kind of a legal term. And it talks about a legal process that's set by state rules. Every state is different. Kentucky is very different from California, and it's very different from North Carolina and everywhere else. Every state is very, very different. And so if you think, well, I used to live in this state, I'm sure it's all the same, just understand it's very different in every single state. Okay. Also, when you die, and if you are using the probate court process, that there's a delay. Okay. And the delay is your beneficiaries cannot get the assets for at least 6 months from when you die and when they open the estate. And generally, it's about 7 to 9 months. So there's a delay in getting your assets to your beneficiaries. Also, the control is with the courts. Okay, so to close out an estate in a probate court process, all the beneficiaries have to agree. Okay. And so they all have to agree through the court process. So the court is in control. Also, all the beneficiaries are in control. So you're giving up control. It's no longer just you deciding everything. And so if your children don't agree with what you've done in your will, they can challenge it. and it's all public record. Everything, how much you own, who it's going to, all those things are become public. They're filed at the courthouse. Anybody can go by and see. They can say, oh, Ben, you passed away. You had this much money. These are your children. And this is who you left it to. All that is public information. And so if it matters to you that information is public, then you do not want to go through the probate court process. Also, there's a cost. AARP estimates that there's a cost of 5 to 20% to your estate by going through the court process. I have read other information providers besides AARP that verify that the cost is between 5 to 20%, depending on the size of the estate. And generally, unfortunately, the smaller the estate, the higher the percentage, and the higher the estate, the lower the percentage. And so, which is kind of reverse on how you would think it would be, but that's the way it works from the studies that have been done from my reading. And but anyway, state law allows an attorney to charge 5% of your estate. The executor is entitled to charge 5% of your estate. There's also court costs. Court costs have at least doubled since I started practicing law. And there could be other costs. If there's litigation, if there's a trust within the will, that can cause additional cost. And so just think about this, just do the math. On a $100,000 estate in Kentucky, you could be paying anywhere from $5,000 to $20,000 for attorney fees, executor's fees, and litigation costs, court costs, and those are real numbers. And I hate to tell you, but I've actually seen cases, estates where there was issues that arose where the attorneys ended up taking quite a bit more than the 5%. And so just understand that if you're using a will and you're going to go through the probate court process, that 5 to 20% of your estate on average is not going to go to your family. Okay. And so if you want to save your family money and you want to save your family some time, and if you want to save your family from having all this done in public, then you need to avoid the probate court process. Okay. And in order to do that, you've got to use a vehicle other than a will to do that. Okay. Let's go to the next slide. Okay, the next thing is what is a trust? A trust is good for a lot of things to avoid a lot of the issues that we have with the will and the probate court process. So a trust is very handy if you've got disabled beneficiaries. It's very handy if you've got minor beneficiaries. It's very handy if you're worried about protecting your children in the event that you die and you're wanting to make sure your kids are provided for in the event that your spouse remarries. A trust can allow for remarriage protection. Also, a trust can provide asset protection. So if you're worried about protecting your assets from a nursing home, you can use an irrevocable trust, and that protects your property from the nursing home or your creditors. If you're wanting to avoid probate court or provide remarriage protection, you can use the revocable trust. I have the revocable trust. That's what I've got for my family, so that will avoid probate court. It will also have remarriage protection. So if I die, my wife can get remarried, but half of my assets will be set aside and protected for my kids. They cannot be touched, and so that protects my kids. So what we always say is a trust is like a little red wagon. All of us probably, hopefully, had a little red wagon when we were little kids, and we always pulled it around and put stuff in it. And I remember my little red wagon. It was my sister's little red wagon. It was had stickers and was rusty by the time I got a hold of it, but it still worked. And I played with it all the time. And I would take it out in the yard and I would put, rocks in it. I would put some soccer ball in it. I would put my stuffed animals in it. Anything I wanted to put into my little red wagon, I would. And when I was done hauling that item around in my red wagon, if I wanted to get rid of it, I just took it out of the wagon. And so that's kind of the way a trust works, if you will, in that if you want to put your bank account and your house and your life insurance and your car all into a trust, it's a little red wagon in that it will hold all these things for you. And that's really good, because if you should become disabled, then your family doesn't have to go around searching for all your assets. They don't have to use your power of attorney and fight with people about, is your power of attorney valid? Has it been updated? Do they recognize it? All those kinds of things. So if you become disabled, you have your accident or illness, and your family needs to get in control of all these assets. If they're all in your little red wagon, your trust, then they don't have to do anything other than just contact where these assets are, tell them that what's going on, show them that they're the trustees now, and it's much simpler for them to handle if you've had a stroke or accident or illness. And so a trust is very, very helpful if you've got your assets all in the trust and you should become disabled. Also, when you pass away, when you're done with your little red wagon, and you pass away, and you want to get these things that you've put in the wagon to the next people that are going to use the things, all you do is turn the wagon over to those next people, your beneficiaries. And so that's why a trust is so effective. You don't have to go to court with a trust. You don't have to go through probate court with a trust. You don't have to hire a lawyer to administer the estate with a trust. It's very simple. If you've got it all properly funded and it's properly set up, then having a trust when you pass away can be very, very easy for your family to handle your assets if you should have a disabling injury or illness or accident, or if you pass away. And so also want to dive in a little bit just between revocable and irrevocable. Again, I have a revocable trust. That means that I can amend or change my trust at any time. And I can change the beneficiaries. I can change the trustees. I can change who gets the stuff. I can change what's in the trust. I can take stuff out of the trust at any time. And so it's really easy to work with the revocable living trust. And the big benefit, again, is you avoid probate court and you can do remarriage protection. Also, think about this. You can actually do planning for your children. You can leave your assets in trust for your kids, and so that you've left assets for them. If they get a divorce, that in-law can't come in there and do that trust and get the stuff. Also, if your child dies, then the assets are in that trust and they avoid probate. So you've avoided probate for you, your spouse, and your children, all with a single trust. And so it can save a ton of money for your family and a ton of time and energy working through all those estates. So, and the other kind of trust that we do is the irrevocable trust. And again, that's the asset protection, irrevocable trust. It's used to protect assets from creditors, including the nursing home. And so that's a very unique type of trust. You retain the power of appointment, so you can change who the trustees are. You can change who the beneficiaries of that trust are. The one thing, though, you cannot be the direct beneficiary of assets. So if you put a house into the trust, you can't just take the house out of the trust and give it back to yourself, okay? You can sell the house and buy a new house within the trust. The trust sells the house, buys a new house. That new house is put into the trust, but it stays in the trust. If you put money into the trust, that money can be used to buy a CD in the name of the trust, but the assets stay in the trust. Now, there's two kinds of irrevocable trust. There's a trust where you can pull income out and it can come back to you, and there's a trust where everything stays in the trust, income and principal. It kind of depends on what you're wanting to use the trust for. If you're wanting just to protect the house, we use the trust where you're not pulling anything out. If you're wanting to protect the farm but still pull income out of the trust, then we use the trust where you can pull income out but leave the principal. Okay, so it has to be tailored to your needs and your desires. Okay, and again, both of those trusts avoid probate court. Both of those trusts are in place of your will. All right, so let's go on to the next slide. Let's see how the way you own your assets affects your will, trust, or other estate plan. Okay, which leads us to threat number 3, to your estate plan. Not knowing your predators, and you'll be surprised, they could be right next to you. And these are your predators. The government, if you're stuck with their rules, remember we're trying to create a rule book for you. The IRS, if you have tax issues, lawsuits, we always need to be worried about lawsuits. Family members can be possible predators, nursing homes and nursing home care costs. So those are all the predators. And so we're going to try to create a plan that's your rules that protects you from your predators. Okay? All right. So let's move to the next slide there, the key tax provisions. So a lot of people are confused and they're scared of doing estate planning because they're scared about taxes. Okay? In fact, I had a client come in recently and she was confused about the difference between income tax and inheritance tax and gift tax. And so she came in and she said, Mom has placed her account in my name. We own it jointly. And I know, this is what she said. She said, I know that when Mom dies, that I'll get that money and that I'll have to pay a whole bunch of income taxes on the money that she's giving to me. Okay. So think about that. Mom is giving her money. Mom is deceased now, and she's worried about paying income tax. Okay. So that kind of shows you the problems that we have when we don't know the law. She kind of knew enough about the law to be dangerous, right? She had done some estate planning. She had put money into her name jointly with Mom as to hopefully avoid probate court. And she was thinking, though, that could cause some tax problems down the road. And so I told her, I said, you don't have an income tax problem. There won't be income taxes to pay unless that money is earning income. And so I said, what you're worried about is inheritance taxes. And, that depends on how much is in the account and how closely you're related. Okay. And so looking at this slide, we know that all of us can give $15,000 per person per year, and it won't count against our lifetime exemption of 11.4 million. And it's actually a little higher now. I think it's like 11.5 million. And then we also know that when we die, that we can give away a whole bunch of money before we're ever taxed. And so this client I was dealing with, they were dealing with, approximately $100,000. And so we know that Mom can give away the money that they were talking about without tax problems. Now, yes, she's going to have to file a gift tax return on the gift that was made, but there's not enough there to have to pay gift taxes. And also there won't be inheritance taxes because she was a daughter. She lives in Kentucky. And there also won't be income taxes because the money was just in a savings account. Okay. So here we had this situation where they were worried about taxes, and there really wasn't a tax problem. And that just kind of highlights that if you don't know enough about the law, then you're probably scared about stuff that you shouldn't be scared about. But there's other stuff you should be scared about. And that's why you need to talk with people that do this all the time. So the reason we talk about this slide right here is you got to be aware that you can make gifts, but they have to be within the amounts allowed by law. Also, they need to be two people that you have to be aware of the tax implications, especially in Kentucky. So if I just give money to a friend and when I die, that could cause Kentucky inheritance tax implications. If I give all my money to my wife or my children, there's not going to be inheritance taxes. And so you need to be talking with people that understand taxes when you're doing your estate planning before you go do all this stuff, because it's always better to do it properly the first time as opposed to come back later to try to fix things. Okay, so let's move to the next slide. Not knowing your predators. We always tell people lawsuits are a potential predator. Most of us really never think about lawsuits being a potential predator, but they really are. And you got to be aware of them. And to explain this, we always tell the school bus story. And so I die and I leave everything to my wife. And it's all jointly held, right? So we've avoided probate court because everything was jointly held, or it was designated as she was my beneficiary. So everything goes to my wife. And so you would think my plan worked, right? I got to avoid probate court. I died. My wife's got all the money. And so everything's perfect, right? And so not so fast. Okay, not so fast. And so this is why this story right here is exactly why you've got to be worried about lawsuits. Okay, let's say that when I die, my wife and all my kids, they're riding along in their minivan and they're arguing. My wife takes her eyes off the road and they don't notice that the school bus is stopped in front of them. And so my wife rear ends the school bus. My family's okay, but there's 13 kids on the school bus and they're all injured. They all have neck injuries. They're all holding their necks and they're all using their cell phones to call the hammer, right? They're all calling the hammer right away to file lawsuits against my wife. And there's 13 of them. And so I can tell you there's not enough money in my insurance to protect, or my wife's insurance to protect against 13 lawsuits. There's just not. And so what happens if that happens and they sue my wife, who's now inherited all this money? They're going to get it all. Okay. And so if we have not used asset protection planning, and she's in this school bus wreck that we've just described, then all the money I've left to my wife is now going to be subject to all these lawsuits that the hammer is going to file against her, and there won't be anything left. My wife and my children will be left penniless because I left everything jointly. So just owning things jointly with your spouse doesn't protect your spouse. Just because it's simple and it avoids probate court doesn't mean it's the right thing to do. And it doesn't mean it's the proper estate planning to do. So you've got to think about asset protection to avoid lawsuits for you, your spouse, and your children. Okay, we'll go to the next slide there, Julie. All right, so not knowing your family members could be predators. This is something that we hardly ever think about. And so your spouse could be a predator. And people always ask, well, how could your spouse be a predator to your estate plan? Okay. And kind of think back my last story about the school bus. What you don't understand is if you own everything jointly with your spouse and you die and you've avoided probate, yay, hurrah, right? Great. We don't have to pay a lawyer to get all the money. But what happens if I die and everything's now in my wife's name and she's very distraught and she decides, you know what, I'm going to build a pool in the backyard to try to make the kids happy because they've lost their dad. And I don't know anything about pools. They get the pool built. They've got to hire a pool boy. They hire a guy named Biff the pool boy, right? And Biff the pool boy, he and my wife get along very well. And they decide to get remarried. They remarried, okay? So my wife and Biff the pool boy are now married. I've left everything to her jointly. It's not in a trust. There's no remarriage protection. Biff the pool boy decides to have my wife get her will redone. And so they do that. She got everything owned jointly with Biff the pool boy. My wife dies, leaves everything to Biff the pool boy, right? And he's promised my wife, oh, don't worry about it. If you die, I'll make sure that your kids get at least half. Guess what Biff the pool boy is going to do? My kids aren't going to be left with anything, okay? I've seen it happen. I've had people in my own family that got cut out when this happened. And so if you die and your spouse remarries, I'm going to tell you, there's at least, in my mind, there's at least a 50% chance that your kids are going to get cut out because your spouse is going to remarry. They're going to leave everything to their new spouse, and that new spouse is going to not leave anything to your children. Okay, that's called the Biff the pool boy story. Okay, so when you're doing your estate planning and you're sitting there thinking, why is a spouse a potential predator? Think about Biff the pool boy, right? Or Barbie the bimbo, right? So that's the other version of this. So ladies, think about Barbie the bimbo. You pass away and your husband remarries Barbie the bimbo, and she ends up with all your stuff, and your sweet little children are disinherited. You really have to worry about that. It happens all the time. And so we also always tell the story about Fred and Wilma. Fred and Wilma, we always kind of think back Fred and Wilma Flintstone, right? But they're sitting on the front porch. They've retired. Things are great. But Fred's worried. They're in their 60s, and Fred says, Wilma, if I die, would you ever get remarried? And the story goes, Wilma says, no, Fred, what are you talking about? I love you. I would never get remarried. Once is enough for me, right? And he goes, well, that's good to hear. And Fred goes, I don't really mind if you get remarried, but if you did get remarried, would you let him live in the house? And Wilma says, Fred, I would never get remarried. Once is enough. Did you not hear me, right? Us guys were never listening. And so Fred just can't let it go. And Fred goes, well, if you get remarried and he moves in, would he sleep in my bed? And Wilma says, Fred, that's enough. End of story. Let me get back to my Hallmark movie, right? Leave me alone. And Fred just can't leave it alone. Like us guys, we never can leave things alone. Never can leave well enough alone, they say. And so Fred goes, now, if I die and you get remarried and he moves in here and he lives and he's sleeping in my bed, are you going to let him use my golf clubs? And Wilma says, Fred, that's crazy. I would never let that happen. And he says, I don't get it. What's the difference? You didn't say it like that before. We were talking about the house and sleeping in my bed. And Wilma says, well, you're a righty and he's a lefty, so he wouldn't be able to use your golf clubs anyways. And so we just say that to highlight your spouse could possibly be a threat. Now, here's the other point. You may have a disabled child, or you may have a child that has addiction issues or financial issues. I've got 5 children. There's at least a chance that one or more of them may have several of these issues. They may have divorces. They may have addiction issues. They may have bankruptcy issues, okay? And the worst thing that I could do to my child, if they've got one of these issues, just to leave all this money outright to them, okay? Just to have a simple will, everything in equal shares to my kids, regardless of their conditions or their problems, okay? So that's why even in our base plan, our base planning, we provide that if you've got a disabled, incompetent, or spendthrift child, that their share can be held in a little trust for them for their benefit. Okay, you've got to have that. And I bet if you go back and look at your base will that you had done 5 to 10 years ago by your estate planning lawyer, almost guarantee there's no protection in it for a disabled child. So just think about this. If your children have an accident, illness, or wind up in bankruptcy court or have other problems, is there protection for them? And if not, you've got a potential threat to your estate plan that you need to be aware of and need to plan for. Okay, so let's go on to the next slide. All right, so nursing home costs or care. This is a huge issue. When I first started practicing law and I was my Aunt Joanne's power of attorney, I think she was paying like $2,000 a month for assisted living. That was a long time ago. And it's gone up. Assisted living now is $3,000, $4,000, $5,000 a month, depending on your needs, depending on your condition. Nursing home care cost, we called Kensington Manor recently, I think, maybe not, maybe it was another facility. But anyway, we understand that the basic cost here in Elizabethtown, Kentucky, are roughly $7,500, between $75,000, but understand that does not include your pharmacy. That may not include that doesn't include your Medicare supplement or your supplementary insurance plan. So it doesn't include a lot of the things that you're going to have that are necessary, that you got to have. So, we're thinking $9,000 a month is easily the cost of a nursing home care. And so, this is just us, but we believe you've got to maximize your options. You want to stay at home as long as possible, get that in-home care, hire a caregiver if you can to maintain some independent living. We truly believe that doing assisted living will actually lengthen your life, lengthen your stay out of a nursing home. So the sooner you get into like an assisted living facility, I personally believe, based upon my own personal experiences, that can lengthen your ability to stay out of a nursing home. And then finally, going to a nursing home if you need 24-hour care. Okay? All right. That leads us to threat number 4 to your estate plan, your health failing, and it's never expected. I always tell people that my grandmother on my dad's side was in a nursing home for 12 years. My grandfather died at 60 of a massive heart attack in his sleep. He didn't expect it. My grandmother didn't expect to go into a nursing home for 12 years. My Aunt Jean died of a massive brain aneurysm when she was 50 years old. She didn't expect it. I had a cousin die. He was a doctor in Birmingham, Alabama. He died unexpectedly of a tragic car accident. I believe he was in his 40s. So here's the thing, you don't know when these things will happen. And so if you believe that you know exactly when stuff like this is going to happen, let me tell you, you don't. And so you've got to plan for the unexpected, and you got to go ahead and prepare, because if you fail to prepare, all you're going to be doing is putting your family in a situation where they're going to be spending even more money trying to sort all this stuff out, and they're going to be expending emotional energy and having emotional pain by not having all these issues resolved, because they're already suffering from your loss or the accident or injury. So you got to make it family better. You got to protect your family and your money. Protect your family and your money. Those are the two principles you got to be guided by. Go on to the next slide there, Julia. So if you were to have an accident or illness and you got to go into the assisted living or nursing home, here's your options. You can pay, you can have long-term care insurance, or the government pays. And so long-term care insurance is something that you got to get while you're younger. It's not for everybody. Not all of us will qualify. Not all of us can afford it. But if you need to go ahead and now and call about it and see if it's something that could help you. And so even if it covers only 3 years of nursing home care, it's worth it. It's worth it, in my opinion. And so we do not sell insurance, but I bet if you call your local financial advisor, that they can provide you with some quotes. I always recommend getting 3 quotes. And then finally, if you can't pay, if you don't have long-term care insurance, then the government will pay for the nursing home care costs that you have. Okay, and that's the government paying. All right. So the government paying for your nursing home, that's called Medicaid. Medicaid is a long-term payer. They first apply for Medicare. Most of us get that pretty easily. And if you're in a nursing home rehab situation, and then once that runs out, generally after about 100 days, then you apply for Medicaid. Okay, you have to apply for it. Okay, and so there's some myths out there that they can take your home, that you have to give your assets away to protect them, and that you have to give your assets away and wait 60 months to qualify, or do everything 5 years in advance. And those are myths. They are not true, and they're not true for many reasons. First, about the home, there's several exceptions to this rule about the home being taken. Okay, first off, if you've got a surviving spouse that's staying in the home and you're in the nursing home, their surviving spouse exempts the home. If you have a disabled child, you can give the house to the disabled child. That exempts the home. If you've got a sibling that co-owns the house with you, you can give the house to your sibling, and that's exempted. And so you can keep the house in those situations. Also, if you've got a child that stays in the home with you, that's helping you avoid the nursing home, and they're in there long enough, then that you can give the house to them as well. That exempts the house. So there's all these exemptions that nobody ever tells you about because they don't know about it. Okay, and so you got to be aware that there's exceptions, that what your neighbor's telling you about Medicaid may not be right. Okay. Also, let's talk about giving assets away. Everybody says, well, you got to give it away to your child before you go in the nursing home, right? And so we have people want to do deeds to their children because a deed is cheap. And they've heard that this is the way to do it. Maybe you've heard of a pocket deed or something like that. So understand that if you deed your house to your child, and that will possibly do some protection, right? But here's the kicker. If your child then sells the house and they do not otherwise qualify for some tax exemption, then your child is going to have to pay what they call capital gains taxes. Capital gains taxes, okay? Because your child doesn't live there, and when they sell the house, if they sell it before they die, they're going to have to pay capital gains, right? And so if you've got your house in your child's name and your child's never going to live there, and you know they're going to sell it when you die, then you're setting them up to have a really big tax problem. And they're going to have to pay 20 to 30% capital gains taxes on the profit. And the profit will be, let's say you bought the house at $100,000 and it was worth $200,000. That is $100,000 profit, okay? And they're going to have to pay $20,000 to $30,000 tax on that profit, okay? Now these things change all the time, so you have to make check with a lawyer, tax accountant, all these things to make sure that the numbers are accurate. But based on today, on what it is today, it's 20 to 30% of $100,000. So think about this. If you think that you're going to pay, let's say, 150 bucks for a deed because you don't want to have to pay money for a trust, because you think that that's saving you money to protect your house, but then that causes your child to have to pay $20,000 to $30,000 of taxes on a house, how is that saving any money? It's not. You do not save money by doing estate planning on the cheap, especially with a deed to the child, okay? You just don't. Plus, here's a really big situation. What if you and your child no longer get along? What if you and your child no longer get along? You all have a falling out. You all get in a disagreement. Or what if your child dies and has not set it up to where the house is protected? That can happen. I've actually seen it. I actually was involved in a situation where a spouse or a parent deeded a house to a child, and she wanted it back, and the child didn't want to give it back, didn't want to undo that deed. So think about this. You've bought this house, you've paid all this money for this house, and you just want the house back in your name, and your child won't give it back to you. These are real problems with doing a deed to a child of your house. And so we recommend to avoid that at all costs because it can really set you up for having really big problems. So you say, what is the other option? What's the other option besides just giving my house away? Put it in an irrevocable trust. An irrevocable trust protects the house from the nursing home, okay? If done properly with with a qualified attorney that knows how to do it, okay? So that's the key. You got to know how to do these things. And so you don't follow the myth. Don't follow what your neighbor did next door with his situation, because it may not be right for you, okay? So finally, the other thing is you have to give assets away more than 60 months in order to qualify. And to explain that myth and how wrong it is, we're going to bring up a little slide. And Julia, hopefully we can do this. You're going to close down this slide, and you're hopefully going to pop up the asset risk analysis for John and Jane Doe. And we're going to show you how this works. Hang with us just a minute. Julia's getting this set up for us. All right. Now, Julia, if you want to, you can mute me and unmute yourself, and you can kind of walk them through this, and then mute yourself and mute me, and we'll go through. I'll add a little bit to it.
Hello, I'm Julia. I'm the client services coordinator here. So when we have a client come in, we always create an asset risk analysis based on their finances. So you can see an example of Jane and John Doe. If you see me circle right here, the money they have in total is over $506,000. This money is at risk if they don't go ahead and put that money into a trust. You see the amount is immediately protected over $335,000 if they go ahead and place their funds into a trust. Only $171,000 is at risk for 38 months based on this analysis.
Very good. All right. I'm going to go ahead and mute yourself to avoid the feedback. There you go. And so very good, Julia. Thank you. So from this, as Julia stated, they've got over $500,000 of assets, and they're going to be able to protect over $300,000 of assets using an asset protection irrevocable trust plan, leaving only $171,000 at risk to the nursing home, and it's only at risk for 38 months. Now, after 38 months, we start saving the cost of the nursing home per month, a per month cost of the nursing home, every month, okay? So after 38 months, so in month 39, if they're still out of the nursing home, they save another, let's say $5,000, okay? And let's say they stay out of the nursing home another month. They're out 40 months. We've saved another $5,000, okay? And so every month you stay out of the nursing home, we're saving more and more money with this asset protection plan. So, this is really a powerful tool to show you what an asset protection plan can do. And so if you're going to your attorney and they're telling you there's just no way to do asset protection planning unless you do it 5 years in advance, well, look right here. We have protected over $300,000, and it's protected immediately. And we only have $171,000 at risk for 38 months, right? And so we can actually protect the whole thing if we wait 5 years, right? But we can protect over $300,000 immediately. So it's really awesome. It's a really great thing for families to be able to do this type of planning. And so we're really proud to be able to do this for families because it's really needed. All right. Go ahead, Julie, back to the slide. And while Julie is going back to our slides, what we're telling people is we are not advocating to not pay your bills. My grandparents and probably your grandparents or you are part of America's greatest generation, and they believe in paying their bills. And so what an asset protection plan does, though, is it protects your right to choose what you do with your money, okay? And so if you want to be able to pay your bills, you still can with an asset protection plan. If your family believes that you need to protect some and set some aside to buy some other things, then they can. So you're protecting your rights, and what you want is what you deem is best. So you're creating your own rules for your plan, and that's what you want is your own rule book. You don't want to have the state tell you what you can and can't do. You want to take advantage of what's out there and use those things to your best advantage for you and your family to protect you and the family. Okay? All right. So what we tell people is everybody is entitled to a free analysis. We'll do a free analysis of their eligibility for Medicaid. You just send us a Medicaid eligibility information form. We can give that to you free. Just call us. We'll email it to you or fax it to you or mail it to you. And you fill it out, provide us with your information, and we can tell you whether you're eligible or not immediately for Medicaid, or how long it will take and what type of planning you could do to save how much money and how long that'll all take. So that's a free service we provide to anybody. You just call us up, and you don't even have to tell us who you are. You can just say, this is Jane Doe. I'm just wanting some information. Just be honest and open with us and getting that information, and we'll give you all we can on an asset risk analysis like we just showed you. Okay? All right. Well, the next slide there, Ms. Julia. So here's the thing, is every case is different. And in order to qualify for VA benefits or Medicaid benefits, you have to qualify, you have to be eligible. And just because your neighbor, Billy Joe, is eligible doesn't mean that you're eligible. And just because your mom was eligible doesn't mean that my mom's eligible, okay? It's all based on income, your debts, your assets, what kind of assets you have. Are you married? Are you not married? Do you have disabled children? Are your children living in the home with you? Do you have a car? All these things go into it. And so I can't tell you, just unless you tell me everything about yourself on these issues, whether or not you're going to be eligible. And so because I can't tell you, neither can your neighbor, okay? And so you have to go ahead and talk with people that know about this, that do it all the time, to know whether you're going to be eligible for these things or not. And here's the thing, the nursing home may or may not tell you. Okay, so they're very, very busy. They're trying to run their operation. And so they may not have time to tell you all the ins and outs of Medicaid. And so talk with us. We'll do a free analysis for you, and we can help you know what's right and what not to do. Okay, all right, let's go to the next slide. All right, that leads us to threat number 5 to your estate plan, failing to plan when you can. Okay, all right, go to the next slide there for me. Okay, failing to plan when you can. Here's the thing. You can either plan or you can fail to plan. It's your choice. And you can take for granted your health and believe that you'll never have an accident or illness, or you can prepare for the inevitable. And we believe in pre-planning. We believe in making sure that your situation is as easy as possible for your family. You want to think about your family and your money both. Okay. And so you have to think about, do your children have disabilities? Do your children have spending issues? Do your children have children of their own? Do you want to protect your children in case they get a divorce or get sued? All these things got to go into the mix of your estate plan, okay? And we deal with standard plans. We do personalized plans. We do them all. And so our planning is a team approach. We do the legal documents. We talk with your financial planners and advisors. We talk with your insurance agents. We talk with your accountants. We believe the team approach is better. And not only do we talk with your financial planners and advisors, we also talk with your family. Okay, we recommend that you bring your family to the table when you do your estate plan. I've already mentioned to you that my dad's family had serious disagreements. And I can tell you they had serious disagreements because they didn't all get around the table when mom and dad were doing an estate plan. Okay, and so when my parents did their estate plan with my law partner, Mr. Graham, afterwards I told my dad, I put my arm around him and I said, "I'm so proud of you." And he said, "Why?" And I said, "Dad, you have now made sure that my sister and I, we don't have to fight about what's going to happen. You've already told us what your plan is. You already told us what you want. So we don't have to fight. We know what you want, and we're bound to adhere to your plan because you've got a plan and you did it right." And so that's what we want for you and your family, because you can either use the government's rules and go through the government system, or you can create your rules. And there's only one way to do that, okay? And so here's what we offer. You got your option one, your base estate plan. That's the kind of plan I had first when I first did my first estate planning. Option two is revocable living trust planning. Again, that avoids probate court. Also, you could do remarriage protection. You can protect your assets in trust for your children to protect them in case they get a divorce or get sued. You can even protect it for your grandchildren and great-grandchildren. You can do all kinds of protection, all kinds of probate saving methods with those options. We always tell people to think about planning as a pyramid, okay? And so the base level of planning is thinking about yourself, okay? Planning to protect yourself. The next level is planning for you and your spouse, okay? You got to protect you and your spouse if you're married. So that's the base level, is protecting you and your spouse, okay? And then as we move up the pyramid, you think about your family, your children, your grandchildren, your brothers and sisters, your nieces and nephews, whoever your family is, your friends, your loved ones. And so you think about yourself first, then you go up the pyramid and you think about, how am I going to protect my family? Okay. And then after that, you think about, after I protect my family, how am I going to protect my money? Okay. My assets that I've built. So I want to protect myself, my family, and my money. And then finally, we protect ourselves against potential nursing home and taxes. Okay. So we protect yourself, your family, your money, and then you protect yourself against the nursing home. And that is the pyramid of estate planning that we all have got to think about, because it will guide you to the right decisions on what you need. And it's not simply, do I need a will or a trust? It's like, what level of protection are you at? Are you at the base level? Just want to protect yourself? Are you ready for that nursing home protection? And we're all at different levels. So we also think about planning as an oxygen mask, okay? So everyone here has been on the airplane. As the airplane's rolling down the runway for the takeoff, they always go through the emergency procedures. Among the items they cover, you'll hear them say, if we should lose cabin pressure during the flight, a mask will come down. Please secure your own mask before helping others. And why do they do that? Why do they do that? And here's the reason. How effective are you going to be in helping your spouse or in helping your children or your grandchildren if you can't breathe? If you don't have the oxygen mask on? And how effective are you going to be in helping out your loved ones financially if your assets are not protected, if you don't have your affairs in order. Because if your assets are not protected, how can those assets be used to protect your surviving spouse or your children or your grandchildren, even if, when you're in a nursing home, if you don't have that type of protection in place? So we always think of estate planning as the oxygen mask. Put it on for yourself so that you can protect others, okay? And estate planning is all about your rule book and not somebody else's, okay? So those are our different options there. Let's go on to the next slide. And then the irrevocable trust, this is the asset protection trust. We offer what they call an IPUG. In this type of trust, you can still be the trustee of the trust. You still get to decide who are going to be the beneficiaries of the trust. You still get to decide who can be the trustees of the trust. That's called the power of appointment. But you cannot be the direct beneficiary of the assets in the trust. However, you can possibly receive income in what they call the MIT trust. So there's different trusts depending on your needs and your benefits. But this is the type of trust you're going to want if you're wanting to protect your assets from the nursing home. Okay? And this is the type of trust that also protects against lawsuits as well. Okay? So threat number 6, that leads us to not working with qualified professionals. That's threat number 6. And who should be involved in your estate planning? Your attorney, your financial advisor, your accountant, and appropriate family members. We personally believe anybody you're going to appoint as a power of attorney or a trustee or as an executor needs to be at the meeting in some form or fashion. We can Zoom them in now. We've got Zoom. They can be in Wyoming and you can be in Kentucky, and we can Zoom them in for at least part of the meeting. They don't have to be there for the whole meeting. Include your loved ones in your planning. It really makes a difference. My sister and I, she wanted me to be my parents' executors. I wanted her to be the power of attorney. Because we were at the meeting together, we planned it together with my parents. We said, let's do it together, right? Let's actually be a family and work as a family team. And so, we really think that's the best way to go. And so the general attorneys, I guarantee you they're great guys, they're great men and women, but they may not be able to help you protect your assets and use asset protection trust, okay? So nothing against just general practicing attorneys, and it's just kind of like you kind of compare it to a surgeon and a general practice doctor, okay? If you need surgery, the general practicing doctor sends you to a surgeon, okay? And so that's kind of the same comparison that we draw. This is all that we do. This is all we're focused on is estate planning, asset protection planning. So we'd love to help you out. And so that's just a thing that you need to be thinking about, that your estate planning attorney needs to know about asset protection law and Medicaid law to properly plan for you and your family. All right, and next slide, threat number 7 is not knowing the real cost. And the real costs are monetary and personal. I've already explained to you that my grandparents did not have an estate plan. As a result, my family, my dad's family, split apart. And so when I became a lawyer, I made it my goal to help families out. But guess what? I was just a general practicing attorney. And so I was giving everybody the same general information that every other general attorney was giving for a long, long time. And it wasn't helping families. And people were coming to me and I was saying, well, just maybe do the deed of the house to the kids, or here's just a general power of attorney that I learned about at some seminar. And unfortunately, that was not helping families, okay? And so I was not doing the one thing that I became a lawyer to do. And so I devoted my life and my practice to helping others. And so I went back, I got special training on trust, irrevocable trust, Medicaid law. I spent hours upon hours of training on these issues so that I can help you and your family, okay? And so that's what I want to do. It's all about helping your family and protecting you and your family. Remember the pyramid. Remember the pyramid, okay? And I guarantee you when you have an estate plan done, you will feel so good about making sure that all that's done, and you'll feel great. It really is a good feeling. All right, on to the next slide. Not knowing the real costs, how to reduce costs. We believe in team approach as opposed to solo approach. So you got to keep your plan current. We offer maintenance plans, so you can pay us an annual fee. We promise to keep you current. The laws change every July. There's new laws coming down the pike right now. And so we will reach out to you and tell you what the current laws are and how they impact your estate plan. And by being a part of our maintenance plan, you get a reduced rate on any changes that we may need to do. All right. So how much is this going to cost? There's only one way to find out. We've covered these things: losing control of access to your assets, not knowing the law, not knowing your predators, your health failing to plan when you can, not working with qualified professionals, and not knowing the real cost. All right. And so there's only one way to find out, is to plan when you can. There's only one way to discover what you need. And because you have watched this workshop, you are now entitled, go on to the next slide there, you are now entitled to a 1 free hour consultation. We will do a free estate plan audit, and we will go over what you have, what you don't have, and tell you what you need. And all that's covered in that free consultation. No obligation. You don't have to hire us. And we always tell people, we don't care if you hire us or somebody else. We just want you to have a good estate plan that takes care of you and your family. So perhaps your estate planning attorney can do that. That's fine. We highly recommend that you work with whoever you're comfortable with dealing with. Just make sure that you address the issues that we've outlined in this workshop. Okay. So finally, hopefully you will be able to do an evaluation for us. Hopefully you learned a lot, time went fast, and you had a little fun. So I wish you all the best, and I hope that we have helped you in some way, and I hope that you will be benefited from watching this workshop. Take care, and God bless.